Hello, I am Akeisha Johnson, Director of Litigation at Lakeshore Legal Aid. Lakeshore Legal Aid is a not-for-profit law firm providing a range of free civil legal services to people who are low income, seniors, and survivors of domestic violence and sexual assault in our communities. This screencast will walk you through the basics of preparing your will. Having a will lets the court know how you would like your assets to be distributed after your death. It is important to have a will if you own any property or have children under 18 years of age. You can choose someone you trust to act as the personal representative for your estate. This person will manage the distribution of your property after you die. If you don't have a will, those decisions will be made for you according to state law. Additionally, if you have children under 18, you can name the person you would like to act as their legal guardian. You are called the testator, and your will should include basic information about you, including your name, address, and the date you signed the will. You should include language that states this is your last will and that it takes the place of any will previously drafted and signed. You should also state in your will who gets what property, including bank accounts, real estate, vehicles, or any other personal property. If you have children under the age of 18, you should name a guardian for the children. Although this is not legally binding, it gives the court guidance on who you wish to care for your children. Your personal representative will carry out your wishes that you laid out in your will and will also pay your debts. If you have specific wishes surrounding your funeral and burial, you can also include this in your will. There is property that will be passed immediately upon death and does not need to be included in your will if you have provided a named beneficiary. Some examples are a living trust, life insurance proceeds, funds in an IRA, 401k, or other retirement account, securities held in a transfer on death account, payable on death bank accounts, or property you own with someone else in joint tenancy or tenancy by the entirety, and a ladybird deed. You must be competent and under no duress during the drafting and signing of your will. The signing of the will must be witnessed by two adults who see both you and each other sign it. It is helpful if they are people you know who could be located to testify about the will if necessary. A person who will inherit from your estate after you die can still serve as a witness. You do not need to notarize your will. You do not need a lawyer to help you draft your will. But if you own a business or have complicated property division issues, it may be prudent to speak with an attorney. You can take your will to the local probate court for storage. You will need to pay a nominal one-time fee for storage. If you prefer to keep a copy of your will at home, store it in a safe location. The statutory will is a form created by Michigan law. When the form is properly filled out and executed, meaning it is signed by you and two witnesses, it becomes a valid will. The form has a fill-in-the-blanks format. This limits how you can distribute your property. However, using the statutory will has some advantages. You can prepare and execute it without help from a lawyer. Only Michigan residents can use the statutory will. Also, if you have a lot of valuable property, or if your estate or family situation is complicated, you may want to have a lawyer help you prepare your will. Those complications may include children from previous relationships, children with special needs, wanting your property to go to non-relatives instead of your relatives, not wanting your children to inherit equally, and owning a business. If you want to learn more about preparing your will, contact our Counsel and Advocacy Law Line or our estate planning clinic at the phone numbers listed on this slide. We hope this information was helpful. Thank you.